Section 27. After closing, when a happy buyer becomes an ADRE complaint. It has been 3 months since Ashley received the keys to her Gilbert home. The boxes are finally unpacked. The sectional Daniel told her not to finance before closing is sitting in the living room. Ashley has settled into the neighborhood, and Daniel has moved on to other transactions. Then, on a Tuesday morning, Daniel's phone rings. It's Ashley. She doesn't sound happy. "Daniel, we have a problem." Those 5 words can make any experienced real estate agent sit up a little straighter. During a heavy Arizona monsoon storm the night before, Ashley noticed water entering near the family room wall. She calls a roofing contractor who tells her there appears to be evidence that the area may have experienced previous water intrusion. Ashley immediately remembers the SPDS. "Daniel, the seller disclosed that old roof leak. But what if this is something different? Did they know about this? Did you know about this?" Now Daniel's transaction file becomes extremely important. Here's something new agents don't always understand. Closing doesn't erase the transaction. A buyer who was thrilled on closing day can become frustrated months later when the air conditioner fails, the roof leaks, termites appear, a neighbor disputes a boundary, an HOA sends a notice, or the buyer discovers something they believe should have been disclosed. And when that happens, one of the first questions may be, who knew what and when did they know it? Daniel does not become defensive. He doesn't tell Ashley the transaction is closed, that's not my problem anymore. He listens carefully, avoids making accusations against the seller or listing agent, and tells Ashley he will review the transaction information and notify Michael, his broker. That's an important broker tip. When a former client raises a serious allegation involving disclosure, misrepresentation, money, property damage, or potential liability, don't start freelancing. Get the broker involved. Daniel opens the transaction file. He finds Ashley's SPDS. He finds the inspection report. He finds the BINSAR. He finds the seller's response. He finds the roof repair documentation that was provided during the inspection period. He finds emails showing that Ashley and Tom discussed the previously disclosed moisture area. He finds documentation concerning the additional evaluation Ashley obtained before proceeding. Suddenly, those documents Daniel carefully retained aren't administrative clutter. They tell the story of the transaction. Michael has a broker rule that every agent should remember. Your transaction file may someday have to explain what happened when you are not in the room to explain it yourself. Imagine the opposite. Suppose Daniel remembers talking to Ashley about the roof, but there is no email, no note, no report in the file, and no documentation showing what information was provided. Ashley says, "Nobody ever told me." Daniel says, "Yes, I did." Now we have 2 memories. That is a much harder position. ARS Section 32-2151.01 establishes important transaction record requirements for Arizona brokers. The employing broker is responsible for maintaining required records, and agents must follow brokerage procedures for submitting documents and communications that belong in the transaction file. Your phone is not your transaction management system. Your memory is not your transaction management system. And your personal text message history should not be the only place where an important client instruction exists. Here's where many agents get into trouble. They keep the contract and closing statement, but fail to preserve the story behind the contract. Important emails, disclosures, notices, inspection-related documents, written client instructions, and other transaction records required by law or brokerage policy. Now let's change the facts. Imagine Daniel had personally observed substantial water damage during the showing. Imagine the listing agent told him the seller had a major leak last monsoon, but we're not putting it on the SPDS. Imagine Daniel never told Ashley because he was afraid she would cancel. That is no longer merely a documentation problem. That could become a disclosure problem. AAC R428-1101 imposes disclosure duties concerning certain material information possessed by the licensee. Arizona cases such as Hill v. Jones reinforce why no material information concerning property conditions can become significant in residential transactions. If Ashley believes her agent concealed something material, she may contact Daniel's broker. She may consult an attorney. Depending on the circumstances, she may file a complaint with the Arizona Department of Real Estate. What happens if ADRE becomes involved? An investigation may involve reviewing the complaint, obtaining responses, examining transaction documents, and determining whether Arizona real estate statutes or rules may have been violated. Depending on the matter, allegations can potentially lead to administrative proceedings and disciplinary consequences authorized by Arizona law. This is why experienced agents shouldn't ask, "How do I avoid getting caught?" The better question is, if an ADRE investigator reviewed my file tomorrow, would the file show that I acted professionally? Would the file show that Daniel delivered documents? Would it show that Ashley received material information? Would it show that Daniel recommended appropriate investigation? Would it show Ashley's decisions? Would it show the BINSAR process? Would the documents support what Daniel says happened? That's real risk management. Daniel and Michael review Ashley's file. Based on what they have, they can see that the prior roof issue was disclosed, investigated, discussed, and documented during the transaction. That does not automatically determine who is responsible for Ashley's current problem, and Daniel should not give her a legal conclusion. Ashley may need additional professional or legal advice depending on what the new investigation reveals. Daniel calls Ashley back. He doesn't say, the seller is definitely liable. He doesn't say, you have no case. He explains what the transaction file shows and helps her identify the appropriate next steps without pretending to be her attorney. Ashley is frustrated about the leak, but she appreciates that Daniel can actually show her what happened during the transaction. Good files don't guarantee that nobody will ever complain. Good files help demonstrate what actually happened. We're now down to the final 2 sections of Ashley's journey. In the next section, we're going to take everything we've learned and build a practical Arizona buyer representation risk management checklist. The habits that help protect the buyer, the public, the brokerage, and your real estate license from the first conversation through closing and beyond. Online discussion 1. Ashley calls Daniel 3 months after closing and claims a property condition may not have been properly disclosed. What should Daniel do? Daniel should listen carefully, avoid making unsupported accusations or legal conclusions, review the transaction records, and promptly involve his broker when the allegation concerns disclosure, misrepresentation, potential liability, or another serious issue. The existing documentation can help establish what information was available, what was communicated, what investigations occurred, and what decisions were made. Why can transaction documentation become especially important after closing? Answer: disputes may arise months or years after the transaction when memories are incomplete or conflicting. Properly maintained records can demonstrate what disclosures were delivered, what investigations occurred, what instructions the client gave, what notices were sent, and how the parties responded. Documentation helps create an objective record of the transaction, rather than relying solely on recollection. 3. What questions should an agent ask when evaluating the quality of a transaction file? Answer: a useful question is, if my broker or an ADRE investigator reviewed this file tomorrow, would the documentation accurately show what happened? The file should reflect required documents and important communications, disclosures, notices, client decisions, and transaction events consistent with Arizona law and brokerage policy.